of the capitalist system was saying l'exploitation de l'homme par l'homme. It's true that that was in 1843, 48 rather, when he published the Manifeste du Parti Communiste, but things have evolved. And we are here today to think about the evolution of labor law. Today, when we talk of employment law, you can take it as an equivalent of labor law. Labor law is employment law is labor law for our discussion of today. What does therefore the law say about those relations? The Mauritian Civil Code, I just remind you of the origins of the Civil Code. The Civil Code was called the Code Napoleon. It was enacted in France in 1804 and extended to Mauritius in 1805. Then in 1810 came what we all know as the Bataille de l'Île de la Passe, la Bataille du Grand Port, where the French won in a naval victory over the British. And then the British invaded by land from the north, Anse-Larrey, with about 15,000 troops, and they took over the island. And I'll just remind you that in the Acte de Capitulation, when the French surrendered to the British, in Article 8 of the Acte de Capitulation, it was written that Mauritius would keep its laws, religion, and customs. So Mauritius kept the civil code which had just been enacted in France. And therefore, this civil code is still here. And we shouldn't, very often we talk of French law applied in Mauritius. It's French law applied in Mauritius. It's Mauritian law. Mauritian law is inspired from English law. I say English and not British. From English law, and Mauritian law is inspired from French law, but it is Mauritian law. It's called le Code Civil Mauricien. And in contracts, the Code Civil governs all relations regarding civil rights, criminal rights evidently. So civil rights are governed by the Code Civil, and when someone is employed, it is a contract of work. It is a contract which is still governed by the articles of the Civil Code. So contracts generally are in Article 1101, which states what is a contract. Le contrat est une convention par laquelle une ou plusieurs personnes s'obligent envers une ou plusieurs autres à donner, à faire ou ne pas faire quelque chose. So this is the basis of contracts. Now, you are probably wondering, how does that get mixed up with English law, with Anglo-Saxon law? Well, when we became British officially in 1814, English administration took over in Mauritius. English judges started coming to Mauritius. The courts slowly started talking in English, speaking in English. And what happened was that those English judges brought with them the rules of evidence, the rules of procedure, which were English. So, and new laws were very often taking the shape of Anglo-Saxon laws. So what happened is that there are specialized sectors of activity where English law is mixed up with Mauritian law. Let me explain. if tomorrow you go into a bank to open an account, you will believe probably that the Banking Act, which is English inspired, governs the rules of banking. But when you walk into a bank and you sign to open a bank account, it's a contract, which is governed by the Code Civil. And then when you have signed that contract, then the whole system is governed by what is Anglo-Saxon law, which is the Banking Act. Let me take another example, the landlord and tenant. When I sign a contract, I am a landlord, I sign a contract with a tenant, it is governed by French law, by the Civil Code. But the legislator has intervened to set up the Landlord and Tenant Act. In fact, generally to protect tenants, and therefore the legislator has intervened in the relationship between landlord and tenant. So similarly, in labor and industrial relations, we have the basis of the contract, which is Article 1780 of the Civil Code, but the legislator has intervened because it had to protect workers. It had to protect workers because, generally speaking, employers have always been stronger than workers. So, the basic is still the Civil Code, but the Civil Code refers you to what was then the Labour Act. Therefore, it says that le contrat de louage des gens de travail qui s'engagent au service de quelqu'un seront régis par le Labour Act. I'm not trying to confuse matters, but just for you to understand, the basic law is the Civil Code, and then intervenes Parliament and the legislator through laws and regulations which put into practice those contracts. Very briefly, where have we been with the history of labor in Mauritius? It's just to situate the context so that you understand what you are doing here today. Where are we today? 200 years ago, yes, 1824, slavery was still here. And the Code Noir used to regulate the relationship of work for slaves. And in fact, the slave was and in fact, the slave was une chose, un bien mobilier, qui était possédé par quelqu'un comme une chaise ou une table ou un cheval. Slavery was abolished in 1835, and around the same time came indentured labor, mainly from the Indian subcontinent. And new rules had to be written for those people who were coming in. New rules had to be written regulating labor relations. And as time evolved, came freedom of labor and trade unions. There was an evolution in time, very often linked to labor and political emancipation. The right of association today is contained in our Constitution, which we obtained in 1968. The Constitution does not per se address itself to employment relations, but the Constitution at section 3 protects individual freedom and protects the rights of the individual. And then the right of association is protected in section 13 of the Constitution. And therefore, we have evolved into a nation which is today a welfare state where profit is allowed, the employer is allowed to make profits, but nevertheless the rights of workers are very well respected, and therefore it is what we would call a welfare state. Very briefly, in Mauritius we first had agriculture, and in fact the agro-industry. Among one of the first cultures was sugarcane. Sugarcane imported from Indonesia in 1639, together with the deer, the cerf, which we know in Mauritius. So the Dutch brought along those two things which are still here today, but they took away something which is no longer here. They ate all the dodos. And after agriculture, it was the cane industry, which today has evolved. It used to be sugar cane, now it is the cane industry. Industry and commerce, trading houses were here. We accelerating time, after independence, the export processing zone, industrialization in the 70s, in the 1970s, tourism, and then in the 90s, financial and corporate services, then ICT, technology, and today AI. AI which promises to be disruptive, but on which I won't be talking a lot because that takes a conference of about a week. Before ending, let's not forget that very often you people are generally concerned with the private sector. But the public sector employs about 48,000 people. And my understanding is that when you add up municipalities, local authorities, etc., you reach about 80,000 people. So 80,000 people in Mauritius are regulated by a bit different rules, and very often we don't think of those rules. What we are going to study today, violence at work, concerns everybody. But when you talk of certain laws, don't forget, some of them are sometimes different for the public sector. The PRB is something which is going to come out in the Pew Research Bureau report, which is going to come out in a couple of months apparently, is concerned with the public sector. And then finally, just a quick guide as to what have been in the last 100 years, very important legislations. Employment is on the left, industrial relations on the right. Why do we differentiate there? Employment and labor law is generally concerned with the work contract between the employer and the employee. Industrial relations within an organization, you have collective agreements. You have the system which has been elaborated by the legislator, by the state, to regulate industrial relations. You have the ways to settle disputes, the rights of trade unions. How do you register a trade union? What is a trade union? And all of that is therefore industrial relations. There used to be a time in Mauritius when trade unions were not really allowed. And therefore with the evolution of time, employment developed, industrial relations developed, and one of the, I would say, one of the important evolutions was certainly after the Second World War, when wages started being regulated, when the termination of contract of service ordinance came into force. You will find out, let me just tell you that for your general knowledge, for those who don't know, sometimes you see ordinance, sometimes you see act. What is the difference? An ordinance is an act before we were independent. Ever since we have had our own parliaments, laws are called acts. And before that, they used to be called ordinances. They were from the Legislative Council, which is now our National Assembly. Very important was the Labour Act in 1975 and the IRA, the Industrial Relations Act in 1973, which then on the right evolved into the Employment Relations Act of 2008, and the Employment Relations Act 2008, and on the left here, the Employment Rights Act of 2008. Also very important laws. And finally, qui est très dans l'actualité aujourd'hui, le Workers' Rights Act of 2019. I'm not going to say more than that because I've gone beyond my time. So enjoy your day here, be interactive, and you're not here because you're forced to be here. Please be here because you want to be here. Ingrid, je te repasse la parole.
Thank you very much, Mark, for giving us a brief perspective of the employment law. Maybe on the next occasion we can have a session dedicated for that purpose. So without further ado, I have the honor to invite our first panel on stage, Mr. Mariaven Karamben, Industrial Relations and Policy Matters from the Labour Office. I invite you to come on stage, Mr. Karamben. Mr. Manish Bandhan, Chief People Executive from ENL and Rogers Management Services. And Mr. Suraj Kokil, Head of Human Capital, Marcel Saxon Contracting Limited. And finally, our moderator, the fantastic Kemila Narainu, partner at Risk Consult Chambers. Thank you.
2019 is a piece of legislation which has undergone many amendments, and I will be going on the changes brought by the Finance Act 2024 to the Workers' Rights Act 2019. I think there's a mistake on this one. I will be making a short presentation on that, and we'll be putting a lot of emphasis on 4 main topics. And then we will be also be discussing the other amendments as well. So the 4 main topics are going to be about work from home, payment of remuneration during extreme weather conditions, vacation leave, introducing provisions in relation to a labour contractor, and other amendments. So we see that the section regarding work from home has been repealed completely and has been replaced by a new section 17A. We also see that with the new section, some previous sections are still here, such as an employer may require any worker to work from home, provided a notice of at least 48 hours is given to the worker. But we also see that there are new sections which have been added to provide that a worker is able to disengage from working activities during unsocial hours, and that workers who are required to work during unsocial hours will be paid a disturbance allowance. So as you will see on the screen, the unsocial hours means hours of work performed during weekends between 1 p.m. as on Saturday 1 p.m. to 6 a.m. on the ensuing Monday, and weekdays between 10 p.m. on a weekday and 6 a.m. on the ensuing day. Now, the question that comes to mind, as you can see, I have put the title Unsocial Hours versus Overtime, is how are employers going to deal with a person who's actually supposed to be doing overtime, but those overtime actually fall between on the unsocial hours, that is, as I mentioned, during those hours during weekends and weekdays. So this is going to be something that we're going to discuss with our panelists, because bear in mind that the disturbance allowance is actually of the normal hourly rate plus disturbance allowance equivalent to one-time hourly wage. So it's quite a lot, so it's worth pondering upon. Now you will see that I have mentioned that disturbance allowance is applicable to all employees and workers. Why this is important is because when you look at the Workers' Rights Act, Section 17A, and the regulations with regards to work from home, you see that the legislator meant for those provisions to apply to everybody. For the sake of this panel discussion, I'm going to be calling employees somebody who earns a yearly basic salary of more than 600,000, that is what we commonly refer to 50,000 basic monthly salary. And I'm going to be referring to workers, to somebody who earns less than 50,000 basic salary. So we see that the legislator meant for these sections to apply to everybody, employees and workers. So I believe for some employers, the disturbance allowance can be quite disturbing, because this would mean that directors, managers would also be earning this disturbance allowance if they're working during those unsocial hours at home. So we will be talking about this more than blendedly during the panel discussion. Payment of remuneration for extreme weather conditions. As you will all remember, Mauritius was hit by a gigantic cyclone at the beginning of the year, and we see that climatic changes is definitely affecting Mauritius. So it is a good thing that the legislator have introduced provisions to deal with remuneration during extreme weather conditions, and not only rely on the old provisions when it comes to cyclones. So as we will see, with the introduction of this section 32.6, employer may require an employee to work at the employer's premises, and the employee will be paid 3 times the basic hourly rate. And we can also see under subsection C, where a worker performs work at home, he shall be remunerated at 2 times the basic hourly rate for each hour. I promise this was not meant to happen. Right, the famous vacation leave. It seems that the vacation leave has come to the delight of workers, but is actually a headache for employers. I am not going to go onto the whole section with regards to vacation leave, but will only highlight the amendments which have been brought by the Finance Act, because this is something that we will be discussing more in depth with the panelists. So as you can see, the amendments which have been brought is that the vacation leave is to be taken in minimum periods of 6 consecutive days. Application for leaves must be made at least 3 months in advance, except in special circumstances. Employer may refuse to grant vacation leave on reasonable business grounds. Where a worker is not granted or is unable to take their vacation leave, the leaves must be paid out. With these sections, I believe the question that comes to mind when looking at the provisions with regards to vacation leave, is that whether this will be applicable, just bear with me. Whether this is actually an acquired right or whether it is just a benefit. I explain myself. What I mean to say is that let's take, for example, a worker who, as at October 2019, is earning a monthly basic salary of less than 50,000. Okay? And then down the line, at his performance appraisal in December, his employer decides that he's performing very well and increases his salary. So as of January, and he hasn't yet taken his vacation leave, as of January, he's earning more than 50,000 basic salary. My question to you to ponder upon, and we will be discussing it with the panelists, is whether this person is still allowed to take vacation leave, or has he lost that right when he has started earning more than 50,000 basic monthly salary? We see that there has been an introduction of provisions in relation to labour contractor with the introduction of sections 29A, 29B and 29C. We will be discussing it during the panel. It's good to see that the legislator has put some sort of structure by under 29A by making it a must for the labour contractor to register, to make an application to the Ministry of Labour. We see 29B, which talks about obligations of labour contractor. One interesting aspect is the introduction of liability of labour contractor and hirer contractor. So we see that the labour contractor and the hirer contractor, that is the employer, the hirer employer, pardon me, is jointly and severally liable for the remuneration and conditions of employment of the migrant worker and the payment of any statutory contribution. So we will be discussing how clear it is with regards to the jointly and severally liable and who will be taking what responsibility. So now the remaining amendments which have been brought by the Finance Act, I will go very quickly on these before we start the panel discussion. So there has been the reintroduction of paid time off in lieu of overtime pay. We also see an increase in maternity leave up to 16 weeks on full pay. This is very interesting for the legislature to have put in, especially with the growing elderly population. So it is quite an encouragement for parents or even future parents. We see the introduction of provisions for childcare facilities for an employer having more than 250 workers in his employment. And then the much awaited increase to paternity leaves from 5 days to 4 weeks. We note, interestingly, also the protection of the employment of a worker on paternity leave from termination. And finally, we see some introduction of provisions for notice of termination of migrant workers. So this goes towards protection of migrant workers' rights. So this is it about the presentation. We will now be moving to more interesting discussion with our panelists. Mr. Campbell, Mr. Manchbenden, and Mr. Suraj-Kotier. I will be going back on my point on disturbance allowance. As I mentioned, where do we draw the line between overtime and disturbance allowance? Just to maybe clarify, I will take an example. So somebody who is supposed to be working overtime on a Friday afternoon, let's say for the sake of the example, his finishing time is supposed to be at 7 p.m. He's asked to do overtime of 4 hours, and so the first 3 hours will be normal because it will be before 10 p.m. But what happens to the 1 extra hour which will fall after the 10 p.m.? Will that employee be paid overtime only, at the rate of overtime or disturbance allowance, or will he actually be paid both? I'll ask this to Maurice to start with. That's the thing.
Merci. So the question was, given your example that someone is working overtime, is supposed to be working overtime. I think before that, the idea is to clarify what is the nature of the job of the person. Sometimes we need to look at it from an angle of the sector that the person works in, if the person is also working on a shift system or not. Okay, so that it doesn't apply to this unsocial hours as well. In that case, I think it's quite clear in my view that the person who's has crossed into the unsocial hours, and it has been because to do overtime, then the disturbance becomes paid for that extra hour.
So it will be paid both overtime
and the disturbance.
I totally concur with what Maurice said. And I think one good thing about this amendment, which by the way is not something that is new, it was there since 2020 after the COVID pandemic, this notion about unsocial hours. And I think it's there because I don't know if you will relate to this, but I have personally known many, unfortunately, line managers who have been abusing, on that system because their staff working from home, and then for no reason be sending emails at 10 or 11 at night and expect, an answer like immediately. I think it's a good thing. Now it's up to us to come up with policies. In the example you have given, I think we would have to ensure that the shift that is being defined for those workers, we ensure that maybe they end at a proper time so that they have 11 hours of rest before they resume the next day. So if it's more in terms of a cost control point of view, I would advise that you define the shift in such a way that you end up paying the overtime and you only pay the disturbance allowance when they are really working under those unsocial hours, depending on what shift and especially on what sector the person is working. The main amendment there, I think, is we introduce the ICT BPO sector, which was not previously covered in the previous amendments.
Okay, so this all matter of the organization of the shift of the sector as well.
I would think so.
Mr. Campbell, your thoughts on this?
Good morning. The question is disturbing, eh? Disturbance. The law is clear. The legislator has defined unsocial hours, which falls between 1 p.m. on Saturday and ends on the ensuing Monday at 6 a.m. This is the law. Now, why did the legislator came with this provision? Because representations were received from many quarters that employers at any time is disturbing the peace, no family life of the both employees and workers. We made that difference at the start. Both employees and workers. Those who are drawing more than 50,000 and those who are drawing less than 50,000. So, the Minister of Labour held discussion and came up with this amendment. You know, when a law is passed, we have always teething problem, and it goes through certain amendments. And after having observed the scenery, following the regulations of the law regarding work from home, the minister came with the amendment, and that amendment says that If you are asking me to come to work between those hours and social hours, and I'm working overtime, both should be paid. Both overtime and disturbance allowance. You are disturbing my peace, no family life. To reply to your question, yes, both the disturbance allowance and the overtime should be paid.
Thank you. I think this is now very clear for all of us, free legal advice. Let us now move to what I was talking about, the disturbing allowance being disturbing. I'm more talking about a budget, I think, which you come from a very big company. And isn't this a heavy budget for you to be paying managers and directors as well a disturbance allowance?
Well, I would start by sensitizing my CEO and directors, saying don't send us emails now from after 10. If you're sending emails and so on, so it means we have to pay you also disturbance. So I think that would be a first start. But more about that, I think it's important to clarify to what extent it will apply. Will it be a policy where you're going to apply that across all levels, ranging from the CEO all the way down to the workers, or there will be a cutoff? I think that's one thing that needs to be clarified as well. In my view, it should be there should be a cutoff, especially at the senior management level, where your remuneration includes some of the elements of responsibility that you need to take, because you have a certain flexibility as well when it comes to as a senior manager. Right.
So actually,
I would say from a more work-life balance perspective, the way it is drafted, I think I'm afraid, irrespective of whether you have a CEO or a staff, unfortunately, if you fall in that time frame of unsocial hours, that allowance is payable. So I'm not sure whether on that matter we can have a policy which goes against what the law says. I would rather say let's work out on our schedule of work. As far as possible, avoid having people work on those unsocial hours. And if in extreme cases you have to do it, then unfortunately you have to allow a budget for that and make sure you pay employees accordingly.
okay, thank you. I think then again it comes to the thought of proper organization inside the company. We'll move on to extreme weather conditions. My question with regards to this is that we see in the public sector, in cases of torrential rain, there are circulars which are issued in the public sector, and we do not see this in the private sector. When I'm talking about circulars, it's to say that we are under torrential rain, therefore the office is not going to be opened, or you can leave the office at a certain time. I will ask Mr. Galvin this question first, and then have thoughts of our remaining panelists. Because we are talking about the health and safety of employees, do you not think that it would be proper that circulars be issued both for the private and public sector?
Thank you. When we listen to London Council, Senior Council, Mr. Hack was presenting the historic aspect of labour laws, the evolution of labour laws in Mauritius. He said we have two sectors, the private sector and the public sector. The private sector, they are governed by the Workers' Rights Act. And the public sector, they are governed by the Pay Research Bureau, provisions of the Pay Research Bureau, the PRB, as you call it. But there are certain provisions of the Workers' Rights Act which equally applies to the public service. The question is, when we are talking of health and safety, security. Why? The circulars are not issued to the private sector. This is a question. The employers of the private sector, they have the freedom, but before that, let me explain what the law says. The law is clear. In cases of extreme weather condition, where the National Crisis Committee or under the law, the National Disaster Risk Reduction and Management Act, there is an order that everybody should remain indoors. Then the private sector should abide. No one should go out, and the workers are guaranteed their wages for the day. But if this order is not given, is not made by the National Crisis Committee, or under the law, as I said, National Disaster Risk Reduction and Management Act, the employers of the private sector, they may decide, they have the option, in the field that the workers are working in, they are guaranteeing the security of their workers, their employees. But in the public service, at a certain level, each ministry has a committee, as a welfare, as a security, committee, health and safety committee, where they decide that the weather is deteriorating, although there has not been any order issued. We see that there are circulars issued, employees may be released, or employees residing in the south, because the weather is deteriorating in the south, they may leave, so that the security of the staff, of the workers, of the public officers are guaranteed. But the government, as long as there is no order coming from what I've just said, the government cannot give an order to the public service. We have seen business enterprise, Maurice, the association grouping the employers, the members, they issue circulars telling them it is your prerogative, you decide. If you see you can guarantee the security of the employees, of your workers, you carry on. But if you cannot, then you have to take a decision. You and only you decide. So this is a reply.
Thank you. I'd like to have Manish and Suraj thoughts about this. Do you not think that this is giving too much power in the hands of the employer? Because as I mentioned, it is concerning the health and safety of the employees.
Yes, I would think you're right in saying that, because Mr. Kalman rightly mentioned, when it comes to health and safety, we should have one simple and straight guideline that applies to all employees, basically. But then, in the absence of that, I think it's up to, it's been done actually, it's the case already in most of the enterprises, where we have policies. We've got protocols in terms of when it comes to cyclones or catastrophe. And in case of torrential rain, which is becoming more and more common, we have established protocols whereby we release employees. But now the thing is that, again, let's say the government issues something and says, okay, at 12, because of climatic or weather conditions, we should, all employees should go home. But then, just imagine, we just mentioned earlier, we've got more than 500 employees on the island, 500,000, sorry. So if everyone goes at the same time on the road, just imagine that you have another problem there which can worsen the situation because of traffic congestion. So again, for example, in our case, we've developed a protocol whereby we have staggered departure of employees from the office. Those maybe who stay farther, from the sides of the office, they are allowed to leave earlier, and then we apply it in such a way so that we don't create other types of problem, because very often what happens, the staff and employees are safer at the workplace rather than being on the road, so that's also something that must be taken into consideration. So I don't think just this circular will solve that problem. It's best to have your own policies, and depending on the case-to-case basis, where you are located, what kind of environment you are in, from there you take, form decisions.
Thank you. I think we did see this at the beginning of the year, actually, when we were on the road, and it was a bit of a catastrophe. Manish, your thoughts about this?
Yeah, maybe coming back to the role of government on that. My point is, government has two roles here. One, as an employer, given that as I mentioned that the government employs 80,000 people, that's roughly around 15% of the working population. So the first relationship or responsibility is, as an employer, what they're going to do for their employees, but also the second responsibility is for the rest of the population as well. I think based on that, what we need to establish at the national level is a clear protocol, a bit like what we have for cyclones. So for cyclones, you have a clear policy, a clear protocol, 1 in 1, 1 in 2, 1 in 3, and now you also have the precautionary announcement after that now. So, and that applies for everyone. I think when it comes to, and the way it's been defined is extreme weather conditions. So extreme weather conditions, not torrential, it's torrential rain, that's the term, right? So torrential rain or flash floods, we need to have a clear protocol at a national level, so that at the end of the day, health and safety is primary, the primary condition which applies. Of course, the second element now at an employer level is to make sure that in line with your health and safety policies, you have a clear policy for, just like you have a cyclone policy, a cyclone procedures, you also need to have extreme weather conditions or torrential rain policies. Just like Suraj mentioned, we also have developed our own policy when it comes to the different activities we have. So if you take our example, we are across 10 different industries, and so ranging from aviation, logistics, hospitality, which we consider the essential services. So we have a specific policy there, and then we have a different kind of policy for normal operations where people go to office. So that has been developed, shared, and I understand Business Mauritius also has an example or a template of a policy which can be shared to members as well.
Thank you. I think now we'll move to the subject which is much awaited. It is vacation leave. Yes.
Sorry, Kevin. I think there's one more comment I would just want to make, because remember back on the back close we talk about work from home in extreme weather conditions. Okay? So there is just one technicality that I think we need to pay attention to. There's mention about payment of remuneration when the person is working in extreme weather conditions. If it's working from home, it's twice the basic hourly rate, and if it's on site, it's 3 times the basic hourly rate. Except that, that at the start of the day, when we act on the definition of a worker, there's a list of clauses. There's around, I think there's 20 or 22, which basically, irrespective of a salary, concerns every employee. And you will see there, if you look at the exclusions, 32(6)A is excluded. So, which means that irrespective of whether someone is doing above 50,000, if that person is working on site, but 3 times basic hourly rate is below. but would not be payable to someone, to the same person if he's working from home. Just one technical requirement worth mentioning. Thank you.
Thank you. Yes, so vacation leave. I'd like to know how this is progressing in companies like Rogers, ENL, and Manchester. Do you have in place policies that you're putting in?
Yes, we have to, because it's this month. So what we've decided as a group is, well, as I said, we are across different sectors, and having a group-wide kind of approach is what we advise our businesses. And one of the things I will mention is, just coming back to your question about whether the person who, for example, someone is earning more than 60,000 in January, but when the person is eligible, when the vacation leave applies, is still a worker, we would grant it. So the person will be eligible for it in our view. So coming back to the policy, what we've said is, first thing is, there's an element of administration that we need to manage in this. While the law is very clear, what it does mention is the person takes the worker takes the vacation leave and is eligible to the counter restarts when the vacation leave has been, the person has availed it. So what we decided to do is to move out of that, because it administratively becomes very difficult to manage individual cases. Imagine for 7,000 workers, you have to manage each one by one like that. So what we said is, as from October 2024, is the moment the worker is eligible, the counter restarts. And the person has 5 years to be able to avail of the vacation leave.
And are you putting a restriction as to the time limit when he's able to take that vacation leave, as from October 2024?
So by restriction, you mean the number of days that the person can take, right? 6 days?
Yeah, I mean the period in which he can take it.
So there are certain conditions. For example, in hospitality, you have certain, let's say, peak season, peak periods where, based on business efficiencies, it's difficult to grant vacation leave. So the idea is to align it to the business practices, the different industries where it could apply, where you can grant, and where certain cases where it's difficult to grant based on activities.
Okay. And what I meant by, are you putting a time restraint is, once the person becomes eligible for it as from October 2024, are you asking the person to take the vacation leave within 1 year or 2 years?
We said 5 years.
So much.
Thank you. I would answer this in 2 parts. First of all, we at our other company, I'm not talking about RBL Club, but Men's Saxon, we believe that this benefit of vacation leave should have been something that would apply to every employee, irrespective of salary, because the spirit behind it, in my opinion, is more related to work-life balance, right? So you work, after 5 years you have a good break. So we have decided, for example, in our case, we have a policy where we have extended vacation leave to every single employee, irrespective of a salary. That's number one.
Very favorable for that.
I'm afraid maybe not many companies can afford, but see, again, it's case-to-case basis, right? We are in a workforce where 93% of employees of the workforce draw below 50,000. So to accommodate for another 7%, it's not a big thing to do. So that was the first thing we did. Second, so we have a policy whereby we said, okay, if a person has to take vacation leave within a period of 12 months once he's entitled to, and then it cannot be split in more than 2 parts. The law makes provisions for 6 consecutive days, but as is, so technically, someone could apply on 5 occasions 6 consecutive days to make 30 days. So just as Manish mentioned, imagine the administrative burden of managing all 2,000 employees. If you need to manage, Mr. X has taken in 2 parts, it can be very tricky. So we decided to have it in 2 parts only, with a period of 12 months, applicable to everyone. Obviously, with an amendment that talks about refunding, cashing out when you can't agree on when the person is going to take it. It will apply only to those under 50,000 rupees, because that would be really too much of a financial burden on the company. That's the first part. Second thing I would like to mention here is, again on a technical point, you will have noticed that even before the Labour Act, the restriction regarding salary was never mentioned on a monthly basis. It was always on an annual basis. So right now it's 600,000 annual salary, annual basic salary. So for me, that discussion of someone who was under 50 and then got the 2,000 slight increase just to get above 51, and then the press says, no, now you're not entitled anymore, doesn't stand, in my opinion. Why? Because at the time of application, what the test we need to do is, you need to check the annual salary of that person. So you will take, if you are in October, you will take October 2023 up to September 2024, and you will compute the annual salary. And you will see that someone who was below 50, even if that person gets a 2,000-3,000 increase in the recent months, let's say after July, that person would still earn 600,000. So technically, would be entitled to the vacation leave for those who decide not to extend it to everybody. So technically, for me, that person should be entitled.
The example was just quicker to explain, but indeed the example that I wanted to put forward was, well, there's somebody who becomes eligible for it, but at one point he's actually earning in the last 12 months more than 600,000, but then he's still eligible for it if he hasn't taken it.
Yes, for me there is two conditions to that benefit. First, so it's not, for me, in my opinion, it's not an acquired benefit. It's an eligibility status benefit. So at the time of application, two questions we need to ask ourselves. Does that person reckon 5 years in continuous employment? And is he earning under 600,000 rupees annually? So if it is fine, if you're taking both boxes, then yes, he's entitled in my opinion.
Thank you. So now then, two questions for you in the light of these expansions. Again, the question of whether this is an acquired right or it is a benefit that you can get if you are adhering to all the criteria. And my second question, actually, do you answer this?
So the question is, someone, an employee or worker, was earning less than 600,000 or less than 50,000 rupees in December, and then in January there is an increase and he starts to earn more than 50,000 rupees. The law is clear. The law, this particular section, this particular provision of the Workers' Rights Act and the amendment does not provide for someone earning more than 600,000, more than 50,000 rupees to be eligible for vacation leave. So that employee, when he applies, at the time he's applying, the law comes into effect as from the 24th of October 2024. If he applies in November, he's entitled to it, but if he applies for his vacation leave in January or February after having earned an increase which increases his monthly basic salary to more than 50,000 rupees, and I take the example of my friend, yes, he's right. If at the end of the day he is earning less than 600,000 rupees, this is the law. The law doesn't say 50,000 rupees. We, as if to explain certain people, he says 600,000 rupees divided by 12, that gives you 50,000 rupees. Then if the employee, if the worker is earning less than 50,000 rupees, he is entitled to his vacation leave. But at the end of the day, if he is earning less than 600,000, this is a law. Workers defined in the Workers' Rights Act, someone who earns up to 600,000. Okay? So, but at the time he's applying for his vacation leave, if he earns more than that, he is not entitled to the vacation leave. But it depends upon management. That would be negotiation, as they have negotiated. Those who are earning more, they're earning 75,000, 100,000, they have negotiated their contract. There are certain benefits that they are earning, that those who are earning less than 50,000 rupees are not earning. They can go and negotiate with their directors, with their general managers, with the boss. Okay? But in simple terms, to answer your question, at the time of application, if someone is earning more than 50,000 rupees, he will not get that. This is it.
Thank you, that was very clear. My second question, which is still for you, is as see, some companies are actually putting internal restrictions as to when to take the vacation leave, or a period within which to take the vacation leave. What is your stand with regards to this?
The law doesn't make any provision for limitation. You should take your vacation leave in 6 months' time. You should take your leave, the employer uses his authority and says there is a policy you should take. Any policy which goes against the law, which is not in compliance with the law, I see, is null and void. So, if we are insisting that the employees, that the workers should take their their vacation leave by the end of the year, by the end of June, for administrative purposes, and those who cannot, they do not need that vacation leave for that time being, and the employer is forcing them, is insisting that you should take. The law doesn't make provision for that. The law, as it stands, says that a worker who has completed 5 years, this is a qualification. 5 ans, 5 years, and you are earning less than 600,000 rupees, okay? You are entitled to vacation leave. It doesn't say when that vacation leave should be taken. Now, my good friend Manish said, what is positive in that policy decision? I like to mention that, it I followed. What is positive is that the worker will be entitled to the next vacation leave until and unless he exhausts his vacation leave here. So it is in the interest of the workers that they take the vacation leave so that the next 5 years starts as from the day they have exhausted all their vacation leave. If not, because this vacation leave in the public sector, it's good to know that vacation leave is accumulated, okay? I accumulate that vacation leave, then say accumulated leaves, okay? I can accumulate up to 210, okay? The public offices, okay? But here, it is 30 days, but if you don't take it, you can't accumulate it. So, it is in the interest of the workers that they take the vacation leave as soon as they can, because their next entitlement will start as soon as they have exhausted and paid all the dues.
Yeah,
maybe one point that I think that's important to clarify depending on some of the sectors. For example, hospitality. I see some people of hospitality are out there. So what about peak periods? When you have peak operations back in December, January? I think based on business exigencies, we're not saying no, but it's more, there's a let's say preferred period where it's advisable to be able to manage your workforce, but also your money in order to...
So it's the internal business organization that pushes for this to arise. Thank you very much. I think we will have one last question on the last topic, which is the provisions in relation to labour contractor. So, I don't know whether it applies in your enterprise managed, or maybe more is much enterprise. So, do you have anything to say with regards to this joint liability between the labour contractor and the hirer employer?
Yes, I think if you remember, before in the Labour Act, we did have what we call job contractor, and we saw that joint liability, joint responsibility. With a new current landscape whereby we've got so many, you go to a supermarket, you go to a car wash, you go to a bakery, you've got so many expat workers in the island. I think the intention there was to regulate on that aspect. But then my issue there is that we've got practical problems. Okay? For example, when the law mentions labor contractor, basically that's the agent, right? So it's basically saying that instead of that person has to register with the Ministry of Labour, and then he can bring expat workers and supply to companies. So in the absence of proper regulations, because right now we don't know which sectors are concerned, we don't know, there are practical issues such as bank guarantees. So for those of you who are familiar with expat management, an expat worker is on island for more than 2 years. On the 5th year, normally there is a bank guarantee that's paid. You need to furnish a bank guarantee by the employer. Now, in this case, the employer is the labour contract, is the agent, and then there is the hirer employer, which is basically the company where the person is assigned to work. So then in this case, who furnishes that bank guarantee? You've got issues whereby, for example, you need to take disciplinary actions against that person for any fault or any misconduct, but then the employer is not the hirer employer, it's the labour contractor. How do we deal with that? So for me, there is so many grey areas there. But from a practical point of view, I would think unless we have clear-cut regulations that would be prescribed, I don't see this happening in practice as of now.
Okay, thank you.
Yes. In our law, actually, in practice, actually, employers, they themselves, through an agent, they apply for work permit, okay? Granting work permit to expat to come to Mauritius to work in a particular sector. Actually, you will notice that in most of the sectors, if not in all, the manufacturing sector, construction sector, even in the catering industry, today we have migrant workers. Yes? And we are noticing the phenomenon that there are more and more less Mauritian workers who are willing to work in those sectors. In certain sectors, specifically the agricultural sector, the sugarcane industry, in the field crop sector, even in the EPZ, in the construction sector. So this was an idea which cropped up. I'm just going backwards so that you understand, we understand. This was an idea which cropped up during the discussion that the government had during the budget. Okay? So, the Finance and Miscellaneous Provision Act came with an amendment which we saw labor contractors, and we have the concept of hirer employer. We had this in the past in the sugar industry once upon a time, and the concept has cropped up during the budgetary discussions, and the Finance and Miscellaneous Provision Act made provision for that. What does it provide? It says that there is a labor contractor who brings in workers, migrant workers, expatriates, and then hire it to an employer. This is a concept of hire employer. But the hire employer is not the employer. It is the labor contractor who is the employer. But we came with that, I'm just explaining the law as it stands. But there is a concept of joint liability. That is, in case of non-payment of wages, the hire employer is also liable to the payment to the tune of the sum agreed. This is a provision of the law. Okay? But after that law, were discussions. There have been discussions on that issue, representations on that issue. It's good, I'm sharing with you something new to you, because it is not in the law. The law has already taken effect as from July, 27th July, okay? But there is a policy decision on this issue. Good. That you know, that there is no regulation that has been made yet. No regulations will be made in the future. Maybe in the future, this provision, labor contractor, will be repeated. Okay, so there is no regulation. Interesting to note, and you know it. Even if you apply, there is no policy at this stage to put into practice this piece of legislation. There you go.
I think we have had some insight information at this point.
We use some insight.
Thank you.
Yeah, one point about this, and just to look at it, I think we know we are trends, right? So, and as Mr. Carmen was saying, we have seen more and more foreign labor, what we call migrant workers in the country, and I think this trend is going to increase, especially with the demographic conditions in the country where we have lower birth rates, we have an aging workforce, and we also have high brain drain. The point is, I think moving forward, we will have to have a proper law to regulate migrant workers. In other countries, you have it. For example, I said in Singapore, I remember at that time, we already had the Employment of Foreign Manpower Act, which regulates all your foreign workers, all the conditions, including all the infringements, all the offences of the employer or the contractors. I think that's something which will have to be studied in the near future.
really I think we now have 5 minutes, so we'll be taking questions from the floor, if you have any, on those interesting topics that we have discussed.
Hi, good morning everyone. My name is Chris, writing and working for Bistro. A few questions, I believe the audience will have similar questions. First of all, on the vacation leave, if you can clarify whether it is working days or calendar days, the 30 days. Because that's not clear for many of us in the law.
So you need advice? In my opinion, I think it is calendar days, not working days. But my esteemed highness,
vacation leave. You have 30 days at a stretch. Sundays, public holidays, everything is counted there. Okay? You have 30 days of vacation leave. You do not have 30 days working days. Good? This is a rule.
Okay, so another question relating to the. You discussed about the entitlement for the vacation leave. Yeah? I understand we have to do 2 tests, the test of 5 years and then the test of 50,000 rupees per month. Yeah? But Mr. Government mentioned we need to do the test of 600,000. Okay, then my question is, if you look at overtime, for example, for worker, yeah, if you have someone who, the question is the 600,000, you look at it backward or forward? Because if you have a new employee, for example, who is entitled to overtime, yeah, that employee starts, let's say now in October, okay, and doing overtime, let's say in November. If he's a worker, we do less than 50,000, we have to pay overtime. So we can't do the test of 600,000 at the start. So we use 50,000 per month, yeah. So is there a constraint to use 50,000 per month for vacation as a test?
I think just to clarify, this is what I was saying earlier on. The test is actually 600,000 in the last, I believe it is in the last 12 months. I'll let Mr. Medical Hamdan clarify it and see how the conditions are.
I have to clarify one thing first. When we are talking of 50,000 or 600,000 per annum, this doesn't include overtime. Remember this. Worker is defined under the law, under the Workers' Rights Act, as someone earning up to 600,000 rupees, okay, basic salary. Overtime is something else, okay? This issue has been clarified. Now, the issue is whether we go backward to know that he has been earning. You are earning more than 50,000 rupees, okay, at present. You are earning 55,000 rupees, let's say. Are you entitled for this provision of vacation leave? I would say no. We don't go backward. You have accepted, you have agreed that you be given an increase. Therefore, you have forfeited your right to that vacation leave. Unless your employer agrees, says, no, okay, you are given. This is my position, my opinion. You can't be entitled. Vous ne pouvez pas avoir le beurre et l'argent du beurre. Okay? You have agreed to get an increase in your salary. Vous avez 10 000 roupies. Vous avez. You forfeit your right. We are in the domain of law. Someone may disagree, someone may agree. This is the position. Okay? Thank you.
I think just to clarify on this point, let's say somebody was eligible for the vacation leave as at October 2024 because he was earning less than 600,000 on a basic yearly. Now, at some point in time afterwards, he starts earning more than 600,000 yearly basic salary. Although he was eligible for the vacation leave as at October, but what he said of Mr. Campbell is that down the line, once he starts earning more and he's no longer in the definition of a worker, he loses this entitlement.
Yeah, I think the test that many of us will do is obviously look at the basic of 50,000. I'm not very personally comfortable using 600,000 because it's quite complicated. I think 50,000 is a good benchmark to use. Like all useful payment over time and the benefits that workers get. Yeah. So 2 quick questions on the work from home. I know in the work from home, the disturbance allowance mentioned weekends and after 10 p.m. on weekdays. I would assume that public holiday would be considered like Sunday. Yeah? If someone works on public holiday?
Sunday is considered as a public holiday according to.
Okay, so we apply the same principle. Yeah. And obviously the disturbance allowance will be to work from home. Yeah. Under Section 17. What about if people work on site during those hours? Saturday, 3 p.m., someone is not working from home but working on site, or should we pay I believe we would pay the disturbance as well, yeah?
So what you were talking about this earlier.
As drafted in the law right now, it talks the mentioning work from home, right? I don't think that would be applicable when the person is not working from home as it is drafted. Now it's up to the company to decide whether we want to extend that policy on that particular aspect. Because as it is drafted, it's only for work from home.
I concur with Suraj, actually, because if you were to extend it and have a different perspective, imagine you're doing a team building on a Saturday afternoon. Would you be paying disturbance then? So, very often we do team building on Saturday, so if not, you end up with parties on a Saturday evening. So, you wouldn't say that you pay your disturbance, right? So, I believe that was only for the work from home.
Yeah, but I think for the end of year, we are not paying overtime for people to go to end of the year. Yeah. But maybe you know, Mr. Campbell, from the Ministry of Labour, it is something that the legislature would change in the future, because it looks like if you work from home, you get disturbance. If you're on site, you don't get the disturbance. I don't personally see the logic here.
No, I can't tell you at this stage whether the law will be changed or not. This is an issue you have raised, but the law is work from home. Okay? So you work from home, you are entitled to it, and you don't work from home, you are not entitled to it. So easy, so clear.
Okay, thank you.
Thank you very much, Maurice. I think maybe you have time for one last question from the floor. Or is everybody ready to agree? I see my friend has already approached, so it's going to be the last question.
Thank you. For this on clarity, regarding the disturbance allowance, is it irrespective of sector, or for all sectors it applies? I am in the sector. And we work throughout the hour.
The law has not made any distinction. You work from home. In any sector, if you are being requested to work from home, you are entitled to it. Okay? It's not only in sectors like ICT, BPO, something like that. No. In all the sectors.
This is absolutely. Thank you very much for your attention. I would like to thank my esteemed panelists for their time, effort, and patience with me. Thank you very much.